But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf. And we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Welcome back to the channel, and buckle up, because today's courtroom drama is a perfect storm of legal complexity, defiance, and some serious tension between a defendant and the system. We're looking at the case of State of Kansas versus Matthew Schrader, where the defendant is facing not one, but two misdemeanor charges: failure to register a vehicle and no proof of insurance. On paper, these might sound minor, but wait until you hear how Schrader decides to handle it. Instead of hiring a lawyer, he walks in prepared to represent himself, and what follows is a fascinating look into the risks of going toe-to-toe with a judge without legal counsel. We'll see him push for subpoenas, challenge evidence, and even resist entering a plea. And trust me, it all leads to a critical decision about his bond that could cost him thousands. As you're watching, ask yourself, would you ever take on the court system alone? Let's dive in.
We will now take up Matthew Schrader on the record now in 2025 TR 1342, State of Kansas versus Matthew Kyle Schrader. Jared Regier for the state. Mr. Schrader, do you appear?
I'm here in pro persona sui juris, appearing specially, not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve two charges. Count 1, failed to register a vehicle and classified non-person misdemeanor. Count 2, no proof of insurance, and Class B non-person misdemeanor.
And you said these were allegedly committed when? Which date, according to the document?
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
And location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
Now this moment right here is a turning point. The judge gives Schrader every opportunity to apply for a court-appointed attorney, but Schrader says, nope, I'll represent myself. On one hand, it's his constitutional right. On the other, this is a dangerous move. The courtroom is full of procedures, rules, and legal traps that can trip up even seasoned attorneys. By waiving his right to counsel, Schrader is betting that he can navigate all of this alone. What do you think? Bold confidence, or setting himself up for disaster? Drop your thoughts in the comments.
I will waive my right and present myself.
All right, is anyone making you waive your right to an attorney today by any threats or promises?
No.
Or any other reason?
No.
All right, and you do understand for the record that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
All right, I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count one, fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the U.S. mail. If you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you'd get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
Here's where things heat up. Schrader reveals he subpoenaed the sheriff's office for body cam and dash cam footage, but they hit back with a motion to quash. That's legal speak for, we're not giving you what you want. And this is critical because evidence like body cam footage can make or break a defense. Schrader insists he won't enter a plea until he gets this material, essentially putting the brakes on the case. This is classic self-representation strategy, overwhelm the system with demands. But judges don't like delays. The question is, will this help him or just frustrate the court?
All right, you have filed a written motion for subpoena of what documents from the Butler County
Subpoena
Sheriff?
Ducis Tecum.
Of what?
There are many items on there, and
So you don't know what you've asked them to bring to court?
yeah, I do. I don't have it in front of me, but it's a lot of the typical things like body cam, dash camera footage.
All right, and they have filed a motion or a response to quash at least part of what you requested.
Yeah.
Right, and Destiny, do you have both his motion and the response on the file there in front of you?
I show the subpoena, Your Honor, and then I show the
Motion.
sheriff's office motion to quash.
Okay, all right, well, we will set those for hearing if necessary, but how do you want to plead on these charges before we get to that?
Well, I feel like it wouldn't be appropriate to plea until I get the evidence and I'm able to be informed enough to make an appropriate plea.
All right, so you're telling me you don't want to plead not guilty today, you don't want to plead anything today, is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there.
And here's a big one. Schrader refuses to plead guilty, not guilty, or even no contest. In most courts, you don't get that option. So what happens? The judge steps in and enters a not guilty plea on his behalf. This ensures the case can move forward, but it's a reminder of how courts keep control of their dockets. Schrader might think he's in the driver's seat, but in reality, the court sets the pace. Do you think this was smart resistance on Schrader's part, or just another way to irritate the judge?
But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So How much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me
I'm asking you, sir.
how much time I need?
No, I mean, how much time the whole hearing will, you anticipate will be?
20 to 30 minutes.
All right, let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena dulcis tecum and motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information in this before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
The written response and motion to quash does appear to be filed by Mr. Hulskamp, Your Honor.
All right, let's set a motion hearing on a Wednesday afternoon. Destiny, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but
And you do want it on an afternoon, Your Honor?
yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day.
What are you
November.
looking at? I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Schrader. Do you understand that?
Yep, sounds good to me.
All right, if there's nothing further, let's see.
Your Honor, there are multiple matters still to address.
Go ahead, please.
Your Honor, as given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being set, requested, and this matter is being set over by the defense.
Speedy trial time does count towards the defense if he is asking for this motion hearing to be set and that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
And now, the bond showdown. Despite appearing as ordered, the prosecutor asks for a $3,000 own recognizance bond. What does that mean? Schrader doesn't have to pay up front, but if he misses court, the state comes after him for the full amount. It's like having a financial sword hanging over your head. Schrader objects, saying he showed up as required, but the judge sides with the state. This is a subtle but powerful reminder. Even when you're technically compliant, the court has leverage to make sure you stay that way. What do you think? Was the $3,000 bond fair or excessive for what amounts to traffic-related misdemeanors?
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 OR was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by the officers for booking and processing. Your bond will be set at a 3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with Deputy in Court Security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post the 3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
Oh, very well. Look
But-
for that invitation on the breakout screen. And Destiny, if you'll put that on
And
there
we-
for
so
Mr.
you-
Schrader, for the officer in Court Security 2.
What time? So it's November 12th,
The motions hearing is November 12th at 1:30, correct?
1:30.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just put the two of them in a breakout room.
So let's recap. Matthew Schrader walks into court facing charges for an unregistered vehicle and no proof of insurance. Instead of hiring an attorney, he chooses to represent himself. He subpoenas the sheriff's office for evidence, fights over a motion to quash, and refuses to enter a plea until forced. The judge eventually enters a not guilty plea for him, sets a motion hearing date, and slaps a $3,000 bond over his head. This case is far from over, but already it's a masterclass in the risks of self-representation. Some may call Schrader bold, others reckless. What's your take? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.